excited to have you join us again for PPL422 Landlord 2. Remember, Landlord 1, we majored on customary land tenure. Landlord 2, we are now looking at the Land Use Act and other statutes that guide land law in Nigeria. And of course, we have had some topics and I hope you have found them interesting. So today we are treating another topic that will enrich your knowledge of land law and prepare you, to practice well as lawyers in this very interesting and rewarding field. So let's not waste time. Let's go on and see what we have for today. So this is our fifth lesson, and in this lesson we'll be looking at licenses. Some of the things we should be able to do at the end of the lesson. We need to describe the major categories of licenses, explain what a license is, explain the concept of license by Estoppel, discuss the implications of contractual licenses to third-party rights, and the principles guiding transfer of benefit under license. So first things first, what is a license? A license simply is permission. So a landowner grants permission to someone else to enter into his land for a particular purpose. That is a license. Without permission, the other person's entry into the landowner's land would have been trespass. But because permission has been granted, he therefore has license. It's different from easements, profits, and other customary rights that we looked at in lesson 4. And the parties to license are the licensor and the licensee. Licensor being the owner of the land, and the licensee being the person to whom permission has. There are three major categories of licenses. You have the bare license, you have the license coupled with grant or interest, and then you have the contractual license. So let's look at each type. The bare license is also called a gratuitous license. It's a license, it's permission given without any, consideration or any act by the licensee to justify him being granted access into the land. And of course, you know that a gratuitous promise under contract does not in any way, give parties does not give parties any contractual obligations. So same thing for a bare license. Under land law, it can be withdrawn and revoked by the licensor at any point in time. Nothing stops the licensor from withdrawing it. And if the licensor withdraws, a license, then reasonable time will be expected after the expiration of a reasonable period of time, which is a question of fact. If the licensee does not leave the property of the licensor, then he will be treated as a trespasser. Second type of license is the license coupled with a grant or interest. That is the permission that is granted to a licensee to enter the land of a licensor for a particular reason, to enjoy or exploit. That's the reason, to enjoy or exploit the resources on the land of the licensor. So if I ask someone to come into my land in order to cut flowers, that will be a license coupled with a grant or an interest. Now you note that there are two things making up this kind of license. There is the grant and then there is the license, and it is because a grant is tied to the license that it may be irrevocable if the grant is a legal grant. Most times where interest of parties may be affected, the court will prevent the grant being revoked arbitrarily. And of course, a legal license of this nature, where the license gives a legal grant, it will be binding on successors in title of the licensee, except those who purchased with value purchased for value without notice of the license. On that, you can look at the case of Binions and then you have the contractual license. It is a license based on contract. Licensee furnish consideration for the right to be on the licensor's land. Therefore, it is irrevocable. And on that point, you can look at the case of Host Pictures Limited, Host and Pictures Limited, where someone bought a ticket to watch, to enter a theater and watch a movie, and the court held that he could not be, forced out of the theater arbitrarily, because what he had was a contractual license that could not be revoked. So to your first activity, I'd like you to think about it and answer why a contractual license should be irrevocable when a bare license is not irrevocable. So moving on, let's look at the license by Estopel. I will just state the rule and then I will point out some things. The rule is that when someone makes a representation or promise to another person with the intention that it should be relied on, then the maker of the representation or promise will be estopped. That's why it's called estoppel. Will be estopped from acting inconsistent with the promise or representation. The rule was formulated in the case of Ramsden and Dyson. So basically, even if someone, the licensor, makes a promise to a third party and then expects the third party to rely on that promise, he cannot wake up and want to act contrary to it. So in Ramsden and Dyson, a promise to someone that he would become a tenant, and on the basis of that promise, the person invested in, you know, renovations, took active part in directing how the house should be renovated and all, was deemed to have created a situation of license by estoppel, and therefore prevented the party who made the promise from reneging his promise. This is an equitable relief to the licensee. You can also see the case of Wilmot and Baba. Then the question we need to ask at this point is, can a license be transferred? So can permission to one person be transferred by that person to someone else, for that other, the person to whom the permission has been transferred, to have the right, to now enjoy the benefit of the license? The answer is yes and no, depending on the nature of the license. So for a license of a personal nature, that is a license that is attached, it's such that permission was only granted because of a personal relationship or a personal service, that license will not be transferable. So in the case of Inwards and Baka, license to a young man to sleep in a particular property was held not transferable. Where the license is not of a personal nature, for instance, license to a cleaning company to come in and clean premises, that's of a non-personal nature, because any cleaner within the company can come in and clean. And the company can also, of course with agreement with the licensor, may also agree with some other company to represent them if they are unable to make it and carry out the cleaning. For such a license, because it's not of a personal nature, it will be transferable. Our second activity, and will bring the lesson to a close. The question is, when may the benefit under a license be transferable? We just talked about it a few seconds back. And so we have come to the end of the lesson. Some of the things we have learned are what we mean by license. Remember, we said it means permission. Categories of license. We said there are 3 categories. I'm sure you remember them: bare license, license coupled with grant, and contractual license, and the implications for those licenses as to whether they are revocable or irrevocable, and the nature of, attached to them. And then we also learned about the license by estoppel formulated in the case of Ramsden and Dyson, and we talked about whether or not a license will be transferable. You can download this video and watch it again and again, and if you have any questions, you can and post it on the discussion forum, and then we can discuss it. So until our next class, thank you for taking part in the lesson. Thank you for taking part in the course and downloading the video, and take care.